Good morning, everyone. Welcome to today's Knowledge Bank webinar. Today's session is being presented by Russell Pallister from Karntek, and he is going to be speaking to you about legal duties on block managers. The session is being recorded today and will be available to watch back via the News on the Block YouTube channel. If you have any questions throughout the webinar, please submit them in the Q&A box, which is at the bottom of your screen, and we will try to get through as many as possible at the end. Russell is also going to be using Slido within the presentation today, so please do have your mobile devices handy so that you can participate and get involved with that. That is all from me. I am now going to hand you over to Russell to begin the webinar.
Thank you, Vicky. And in addition to the Slido polls, there are some also QR codes included, as we have quite a lot of content to cover today in the session. If I just make clear on that, the legislation that's been published recently related to residential evacuation plans includes a lot of documentation and guidance, which you may or may not have seen, and we've added QR codes at those points that you may be able to scan those and look up some more of the specific information following the session. So good morning and thank you for joining today. We look forward to your participation in the polls and also in the chat and the Q&A. So first of all, we just want to review, take a step back from what's needed for a block to be compliant. I think you can see quite quickly there the wide variety of different areas of compliance that you're now responsible for managing. Some have been in place for many, many years, and some you'll recognise as having more increased recent responsibilities. So when we speak about things like electrical safety and health and safety, there's been responsibilities in that for a long time. Areas like building safety has dramatically changed, including structural safety and other elements of fire safety with it. So if we move on to discuss the growing list of responsibilities, I'm sure you can each relate to these. Block managers seem to have a never-ending list of what they're responsible for, and if we just go through some of these, management of contractors has become much, much more important, and responsibilities of utilising competent contractors, particularly for things like life safety tasks and building safety, and the need of accurate record keeping, the golden thread of information, so certification of works that's carried out, particularly where you've got digital record keeping and sharing of information that has to be managed. So these are increased and changing responsibilities. Also, there's some points in there related to transfer of information. So should a building change hands in terms of its management, the importance and responsibility on those that are handing that over to provide that information to the incoming management team. We've also got areas like resident engagement and mandatory occurrence reporting, a couple of areas that not everyone's completely comfortable with yet. Resident engagement is obviously a journey, it's not a destination, and mandatory occurrence reporting is really about having a process in place to support you when you need it. But you can see all these different aspects to what we've just listed down there. It's very easy, while doing the best you can, being diligent in what you're doing as a block manager. You could put a foot wrong, you could step on something you didn't mean to, hence the point about the reminder there, danger minds. So more than ever before, we have to work together as teams to support each other to actually navigate through these challenges in the more complex world that we live in. The last one on this list is relatively new. Residential evacuation plans have been involved in this for between 9 and 10 months now. So I have some previous knowledge of what was coming up that was published on the 4th of July. We'll come on to a bit more detail on that a bit further on in the session. So I'd like to just pick a scenario here. This is our first Slido poll today. So we'd be interested to see how you are able to answer this one. So the scenario that we've given is we've picked a property called Crystal Court. It's a high-rise building, has 80 flats, by a freeholder called Diamond Freehold Limited. It also has got an RTM company that's been formed, Crystal Court Management Company, 3 voluntary directors and a chairman, John Smith. We also have a block management company called Expert Block Management who have appointed Mary Jones as the senior property manager for the block. So here is the question for the Slido poll. I'm just going to see if that's working okay from this end. We'll just give that a few seconds for you to participate with that and actually fill in your answers. We'll run through the overall results for everyone's interest. So we've got quite a number of different responses coming through across the different options of the answers. So I'm sure this is going to be an interesting one. We've got two that are neck and neck at the moment, so okay, so we'll probably start reading out the results. We seem to have got quite a number of participation so far. So at the moment, we've got Expert Block Management has been suggested as the highest rated at 31%. We've got Crystal Court 25%, Diamond Freehold 19%, Mary Jones as the senior property manager at 14%, and the chairman John Smith at 11%. Now, Crystal Court seems to have risen slightly there. If we just move on to our next slide, you'll be able to see that the responsible person in this example is Crystal Court Management Company. However, just want to make crystal clear here, while we're on this subject, Expert Block Management, as contracted by Crystal Court Management Company, do carry a lot of the duties on their behalf by virtue of their management agreement, and therefore are duty holders. So this is where there are duty holders who have the same responsibilities as responsible persons. Just want to make clear on this point that the term responsible person is often misunderstood. It is not a walking, talking, living, breathing human being. It is a corporate entity. And we do sometimes see this incorrectly listed on maybe a fire risk assessment where they've named the responsible person as John Smith or the property manager, Mary Jones, or even sometimes they might put the wrong entity even. So just want to make that clear. So thank you for participating in that. So what's clear to me is that Crystal Court is correct, and I think overall as we've finished the poll now is showing that 32% of you have got that clear. So that means that hopefully the other 68% have understood something slightly wider here than perhaps you're previously aware of. We have another Slido poll on a very similar example. So I'd like you to again consider this one here. So we're staying with Crystal Court for a moment. The freeholder, Diamond Freehold, there's a right to manage company, the chairman, and so on. And in this context now we think about the Building Safety Act 2022 and who is, in this case, the principal accountable person. So again, we're getting quite a variety of responses on this one. There is one that clearly sticks out somewhat higher than the others. Okay, I think we'll call it at that point. We are a similar number of persons participated to the previous Slido. So we've got Diamond Freehold listed at 38%, Crystal Court at 24%, the chairman John Smith at 17%, Expert Block Management 14%, and Mary Jones at 7%. So if we just move on to the next slide, I just want to be crystal clear again that in the situation where the RTM have got control of the building and responsible for the maintenance of the building, they actually hold the role of the principal accountable person. The frustration widely with this here is then that principal accountable person is represented by, in many cases, lay persons who are not necessarily skilled in management of buildings and normally rely heavily on their block management company to assist them in these duties. However, I'd just like to make clear there are a number of blocks that are privately managed by the management company and not by a block management company that may be competent in helping them with these duties. I just want to pick on a couple of examples here. It's never a property manager, i.e. the senior property manager Mary Jones, and it would never be the block management company unless they had legal ownership of the building. So we have seen this a number of times where persons have incorrectly registered a high-rise building and named the wrong entity in the registration. That then normally has some complications when it comes to your building safety case. So I'd like to make that clear. It's really important that when you register the building and submit the key building information that you do provide the correct answers. So I trust that's been helpful again, just to make this clear for persons. There are times that the freeholder could be the principal accountable person. If it isn't clear if there's more than one accountable person as to who is the principal accountable person through sections 72 to 75 of the Building Safety Act, the ultimate point then is if it cannot be agreed, it may have to be applied to the first tier tribunal for arbitration. Now, as soon as you suggest that, most people shudder and quickly figure out, looking more closely at the definitions of what actually applies, rather than have to go down the route of working with the FTT on this. So thank you for participating in the Slido poll. So now we're going to move on to something that's related to our next subject. You might be looking at these and thinking to yourself, well, what is there to notice? If you're able to actually put something in the chat, this would be great. I'd be really interested in people's responses as to what you notice about these persons. You're probably wondering where this is going. So maybe if I explain a little bit further. We're thinking about this in relation to persons that live in blocks and the differences there may be between those people. Apologies. Okay, maybe we'll leave that if the chat's disabled, and we'll move on through this. So I just want to make clear at this point, there's a couple of things here, if you look a little more closely, that perhaps change slightly. I just want to make a point about the couple on the left-hand side that are having what looks like an animated conversation. What is actually going on here is these persons are using British Sign Language. So this is evidence of a disability that you may not automatically have noticed. And the person on the right-hand side, now that we've updated the picture, you can also see that this person has another disability in relation to sight impairment. The reason we picked on these two examples is because there are a number of impairments that people may have that relate to their ability to evacuate from a building by themselves differently to other persons, but it may not be immediately obvious either. So that's why we've included these couple of examples, just to get you thinking. So I just want to open up the conversation now about residential PEEPs, or personal emergency evacuation plans. So this has been discussed ongoing for almost 8 years now, gone through various different discussion points, but no formal regulation until Friday the 4th of July, that's last Friday, where this was published as the Fire Safety Residential Evacuation Plans England Regulations 2025. And the aim of these are quite simply, as we put here, to assist or create a process and a method by which persons are protected who may have difficulties evacuating. Because there's a lot of information related to this, some of which you may or may not have seen, we've included a QR code here where you can take the link there to follow directly to the guidance that's been published on these regulations. Just to give a bit more detail, we move on to discuss the regulation fact sheet that's been provided. So the purpose of the fact sheet is not guidance as such, but it is to help you understand more the context of the regulation and what it's intended to do and its purpose. So you can scan that QR code and actually see the fact sheet for yourself, which is quite a lengthy breakdown of the different parts within this regulation. I just want to highlight the term specified residential building. This is a new term that's now been added to our list of different building types. We go from high-risk buildings to high-risk buildings to high-rise buildings, relevant buildings, and now we have specified residential buildings. The difference with this one is it includes all high-rise residential buildings with 2 or more flats. It also now includes buildings that are over 11 metres that operate a simultaneous evacuation strategy, as opposed to a stay put strategy. So you might be thinking to yourself, how many in my portfolio am I managing that is over 11 metres with simultaneous evacuation strategy that this is going to apply to? I also think there's a number of things that are set out in this regulation that will be applied probably more broadly to other 11 metre plus buildings that are stay put and also buildings under 11 metres, because at the moment we have no formal controls over these areas, and this regulation, while it doesn't specifically address that, would give indication of the type of approach that's being expected. So we'll perhaps just move on to talk about some of the parts of the regulation that's provided with it. So there's a toolkit that's been provided with it, which is to give some examples of different scenarios that have been provided. This is likely to be updated as we go forwards with more and more information. I perhaps should have said already that these regulations, while they're now published, they don't come into force from an enforcement perspective until the 6th of April 2026, which might seem like a few months away. But what we've tended to find when these regulations have been published is persons haven't started to work on these regulations until after the enforcement date. It's important to remind each other at this point that the purpose of that window of time that's being provided now for persons to familiarise themselves with this is to also put it into practice. So the intent is that by the 6th of April 2026, that you do have what you need in place and you're operating a scheme that meets the requirements of this regulation. So again, we've got a QR code to the toolkit, so you can have a look at that in your own time in a bit more detail. And as I said, I expect that will be significantly updated. There'll be further guidance related to this. So this has been discussed in quite a bit of detail as to providing support for persons putting this into place. I think what you'll notice as you look at the information, the examples provided, though, as we go through the session, a lot of the consultation has been done through councils and social landlords, whose management of their buildings differs in certain ways to how you manage your leasehold properties if you're managing a leasehold block, or different other forms of shared ownership, or persons who've got a collective enfranchisement and have a share of freehold rather than leasehold. The principles, though, that are set out, I think you'll see do relate. There are some elements of the examples that are provided. Just add a word of caution in here. They go beyond what's required by these regulations, and that may be where it's being used for more of a property that's being within a social landlord's portfolio that included a care scheme of some sort, so may go into more detail for that reason. It's important to understand that. If we just then move on to some of these points about the additional resources, there's a couple of screenshots taken there from the resources provided. The examples given vary quite significantly. So if you took an example from Hammersmith and Fulham and you compared it to another council and what they provided, you'll see there's quite a bit of differences. I would like to add something in here related to the subject of additional resources. It is a good practice to consider with your local fire and rescue service, where any block is based, as to what information they're providing on this as well, because you will see there's some differences there. London Fire Brigade, for example, have a PCFRA form that is publicly available on their website, and that is definitely something that could be utilised. But if you are dealing with a property in a different location, you might just want to refer to the fire service for that region and what they're looking for. There's some examples just to pick out of what's highlighted there. This one here has got an example about the time estimated to escape from the property. Now, this is potentially different from one person to another and different from one property to another. and it's not something you always see necessarily included in the PCFRA. I think you've got to keep a little bit of an open mind here and think about it through the lens of the resident and what matters to them and how they're being kept safe and what can be done to keep them safer. Some of the questions then that are asked in some of these PCFRAs won't relate to every type of resident, and in that respect might not be so applicable. So I think it's also important with these persons involved here that we do make sure that they're not confused by or overwhelmed in any way by the questions that are being asked. So this is why I think it's important to understand what's relevant to be asking them in respect of a PCFRA, so as not to alarm a resident. So I'm just keeping track of how we're tracking time-wise, and we're going to get into a bit more of the nitty-gritty related to these residential evacuation plans now. So within the actual regulations, I just want to start off by referring to relevant residents. So what's now termed as a relevant resident in the context of Regulation 4 within these regulations is a resident of domestic premises in a specified residential building where the domestic premises are that person's only or principal residence. So I'd like to just reiterate that which we've listed there, persons whose principal residence is the building, and that second point, whose ability to evacuate is compromised as a result of cognitive or physical impairment or condition. So that's the second part to it. In one sense, you almost need to, first of all, look at persons in your buildings as to what is their principal residence, and then do they have this as a challenge, their ability to evacuate? Is it compromised as a result of a condition of some kind? I think the challenge here is the engagement of residents is particularly important. So you may find this easier when you're dealing with your high-rise buildings because you've already got a resident engagement strategy in place, which is helping you with identifying the persons that are living in your blocks. This may mean you need to take a fresh approach to how you apply some of those principles of resident engagement to these specified residential buildings. So that brings in scope the over 11 metre simultaneous evacuation blocks that you may have in your portfolio. The other point that comes up from time to time related to this is where persons are unwilling to participate. At present, it's not clear how this is actually going to operate, because it is set out in one of the later parts of the regulations about whether a person wants to share their information or not. And it doesn't seem likely at the moment that there's any way to enforce persons to participate in having a PCFRA to evaluate their ability or inability to self-evacuate. Then if we just touch on Regulation 5 then, so the identification of relevant residents in relation to a specified residential building, this relates to the responsible person. So if we go back to the earlier question, the example of Crystal Court Management Company and their relationship with expert block management, most likely the responsibility of doing this may pass from Crystal Court Management Company to expert block management to do this for them. The requirement here then of Regulation 5 is for the responsible person to use reasonable endeavours to identify relevant residents of that building. There's a number of things that we've previously spoken about during the drafting of this regulation, some of which I'd like to share. The obvious one is if a resident is to come forward and tell you that they have a physical impairment, for example, and they need a PCFRA, that would normally be communicated directly to the block manager. But in circumstances, it may also be known to the management company, and they might then have that responsibility to pass that to the block management company that's collating this information. The next point I'd just like to make in regard to this is it could be that one resident is aware that there's another resident in their building that is not able to self-evacuate. We're not clear on this one as to how this would play out, because there does seem to be an element of a right at the moment for persons to announce themselves to you that they need this assistance. If it's obvious that someone has a known disability, they may also have something that's covered later in the regulations about, well, they may have, there's two parts to it. One is whether they have a person that has maybe power of attorney and is assigned, or it may even be a parent of a child that has a physical impairment or cognitive condition. So these other responsible persons then for those individuals would then be responsible to liaise directly with the responsible person to ensure they're aware of the situation and that there's suitable measures in place following these steps of these regulations. So maybe if we just move on to another Slido poll, if that's okay. We've got a question for you all today. How confident are you in producing a person-centered fire risk assessment? It seems to be from our knowledge of this that there's varying levels of people's experience with this. So we're particularly interested to see what you think your approach to this would be as a property manager, we really think about this, or as a director of a block, how would you feel, how confident would you feel, perhaps we should say, in producing a person-centered fire risk assessment? So I can see we've got quite a number of responses so far. One stands out quite clearly. Okay, so at the moment, we've got a reasonable number of responses, and it seems crystal clear at a glance that the outstanding response on this one is persons are not confident, I have no idea where to start. Then the next, maybe a third of that amount are then saying that they're mixed, they've got some ideas of how to do it. We've got very few saying that they're confident, and possibly only one or two people saying that they're very confident, I've already done this. What I've also found is persons who've already done this may be confident in doing similar scenarios, but sometimes you'll then come across a different type of resident with different impairments that you might find more challenging. And that's where, again, you might find yourself back with the not confident category, where you're not entirely comfortable with what is the right measures to be recommending as a result. I just want to just move on then to the next slide. So thank you for your participation in that Slido poll there. We're talking about person-centered fire risk assessments and what it is. I'm sure most have got an idea of what it is. Really, it is looking at all the factors that relate to a person's needs and also the risks, and really looking at both then combined together and what the mitigating measures could potentially be. We've got an example in a picture there of someone being actually evacuated down a staircase using a type of stair chair, of which there's a number of different options around these. There's lots of other simple things that can be done, and sometimes it's not that any specialist equipment is needed, but more that there may be someone else that lives with that person that is able to assist that person evacuating. So it could be you have one person in a flat who has a hearing impairment, and they don't pick up that there is an alarm, they need to leave the building, but they have someone else living with them that doesn't have a disability that can alert them and assist them with that evacuation step. So it can be really simple things. It can be much more complex, where you have a person that's living by themselves that maybe has a more advanced condition like dementia, and it could really significantly impact on how they might respond in an actual incident. I just want to also make clear with regard to all this information, this comes back to residents, and there's something broadly speaking that is difficult about carrying out a PCF array with a resident is when you don't even know that that resident is living in a block. And this is quite prevalent in the private managed block management sector, where there are leaseholders who the block management company know who the leaseholders are, but they actually have no record or live record maintained of who the residents are. This is an important thing that you might need to consider how you manage this going forwards, because if you are not aware of who's in your buildings, you won't be able to liaise with them properly about these arrangements. It might be that the first you become aware that someone's living in the building with a disability is where they contact you, and not because the leaseholder's told you they're subletting their flat. We've covered quite a few polls today, so we won't launch another one on this subject. But I do feel that if you evaluate your portfolio, broadly speaking, what we're finding is somewhere between 50 and 60% of leasehold flats are being sublet. So it's one to be aware of as to how you're going to engage with those residents. Again, if you've already got resident engagement in place that's working well for a high-rise residential block, keep doing what you're doing. If you haven't got something that's working in relation to your over 11-meter blocks that are simultaneous evacuation, you might want to think of how you can adapt or utilize your successful experiences with high-rise buildings for some of those mid-rise simultaneous evacuation buildings. The other point I perhaps should just mention related to person-centered fire risk assessments is there isn't a centralized standard as to what good looks like. There's no regulated standard that has to be followed specifically for a PCFRA. There's lots of examples given by the fire and rescue services across the country which differ in certain ways. This is where it's particularly important that persons carrying out these assessments have got sufficient understanding of what they're reviewing. And most people could go down a tick list and say, has this person got this condition? Yes, no. When you start then evaluating the impact of those conditions, though, that becomes more challenging. And then we get into an area of these regulations that's particularly difficult. So I want to just touch on what then is referred to in the regulations in terms of mitigation of risk. So this Regulation 6 is what particularly applies to the person-centered fire risk assessment. Regulation 7 is then more focused on the mitigation of those risks. So after discussion with the relevant resident, the person that's responsible, and that then might be the block manager on behalf of the RP, is to implement those mitigating measures that are reasonable and proportionate. Now, this is where we immediately find ourselves in the grey areas of regulations again, that makes life a little difficult when these are first published, as to what is classed as reasonable and what is classed as proportionate. I think we've all heard the word proportionate has been used a lot in respect of the building safety regulator being a proportionate regulator. However, if you ask the persons that have been looking at implementing building safety to their high-rise blocks, the word proportionate is not normally the first thing that pops out of their mouths, especially when they look at the proportion of the cost for a relatively small high-rise block, and the cost of implementing some of these measures isn't always considered to be proportionate. So we have this open to interpretation as to what's reasonable and proportionate. I am aware from the discussions in the drafting processes and the review of the implementation of this, there was quite detailed discussion that the point of these measures is they need to make an increased safety. They need to impact positively on the safety of a resident. So one of the parts of proportionate is it actually going to help? There's two parts then with that Regulation 7 Part 1. Part A of Part 1 relates to costs of measures being borne by the responsible person. I think that's with the view that the responsible person is potentially a freeholder. Or secondly, shared by the residents of the building, which is, in simple terms, service charge applicable item. The point then, as we then look at Part B, is subject to paragraph 3, which is later in that regulation that goes through some more details. Implement mitigating measures reasonable and proportionate for the responsible person to take on the basis that the cost of any such measures are borne by the relevant resident. So this then means that the cost might be borne, might be considered reasonable and proportionate by the responsible person, but on the basis that the costs of those measures are borne by the relevant resident. This brings us into this discussion point then as to whether a cost of a mitigating measure is applicable to the service charge or if it's applicable to the relevant resident. Now, this isn't clearly defined enough as far as I see this. The point I think that was considered in the implementation review on this was again along the lines of if the mitigating measure would improve the safety for everybody, even for flats where persons live that don't need assistance evacuating but might do in the future, then that would start to lead towards it being a benefit for the block in the general sense, which would be regarded as a service charge item. The alternative then is if the measure will only ever help that individual and only would help that specific flat with their safety or ability for someone to be kept safe or evacuated, the cost then of that measure would be considered to that individual resident. This, of course, brings up another issue that has been discussed a lot, and I'm not clear where this is going at the moment, as to whether that forms some type of discrimination against persons who have these disabilities through no fault of their own, and now having to face increased costs when some of these persons, from a financial perspective, may not be able to meet some of these costs that might be involved. And we could be speaking about anything from a single flat having a type of sprinkler or misting system provided, which could be considered expensive by comparison to other mitigating measures that might be applicable to the block. I also think the one area I feel hasn't really been addressed very well is the differences in different building types. So if we think about a modern building that's been purposefully built with a fire evacuation lift, this could be used as a tool to help persons evacuate. When we're talking about existing buildings or even heritage buildings that persons are living in that don't have these features, some of these features are maybe not impossible, near on impossible to provide, and the costs that perhaps be associated would be considered extreme and certainly not proportionate. So I feel there's going to be some interesting discussions over the forthcoming months prior to 6th of April 26 as to how practical measures can be put in place that are considered proportionate in regard of these mitigating measures. I just want to touch on Regulation 8. We don't have a specific slide related to it, but it's what's termed an emergency evacuation statement, which is where the responsible person then has to take into account the risks and what safety measures that are in place and look at the reasonable endeavours to agree an approach and kind of come up with an agreed statement between the responsible person and the resident that both are happy with. Now, I don't think that's quite as simple as it sounds in practice, because if the resident's got one idea and the RP's got another idea, the question might be as to how you reach that point of agreement in that emergency evacuation statement. So again, it would be good going forwards if the toolkit could be expanded to include some examples of an emergency evacuation statement and how that's been arrived at based off the PCFRA. So now if we move on to Regulation 9 and discuss the review by the responsible person, where a PCFRA has been carried out, the RP must review and or update the PCFRA and the emergency evacuation statement. It's got to be reviewed every 12 months hereafter. That's from when it's been implemented. Or if there's any reason to believe the PCFRA requires amending, that could be a resident's health deteriorating or a change in their circumstances, or at the request of the relevant resident. As we're probably all aware, since the Grenfell Tower tragedy and the implementation of the Building Safety Act and other fire safety regulations, there's been a significant drive from MHCLG and the Home Office Fire Safety Unit to put residents at the heart of their own safety. And this last point here relates to this. So if a resident doesn't feel that they're safe or that their measures in place are not suitable, they may request the PCFRA to be reviewed. There is also support from the fire service in relation to this, where they are willing to get involved in considering specific circumstances. I'm not sure that they have the capacity to deal with this on a widespread scale, but they are there to support in this area. And I think they're going to be called on significantly to answer some questions related to this and what they're comfortable with as these new regulations have been published. So just to touch on these points here, I think you'd all agree that a person's ability to evacuate or not is definitely something that's a moving target, It's not something that stays static. And it is important to realise that being reviewed every 12 months is a minimum. More importantly, that point is if there is reason to believe it requires amending. So this is where having a strategy for how you communicate with residents is very important. And also, if there's others in your organisation that are having interaction with residents, that they have a way of feeding that information back to maybe the property manager in the first instance to say that we believe that the PCFRA might have changed for this person. So if we then just touch on, it seems like a bit of a flying leap to talk about Regulation 13, but I'll explain why. So Regulation 13 is what's titled Building Emergency Evacuation Plans. Thankfully, there's been no mention of abbreviating this title at the moment. The point I'd like to make clear about Regulation 13 is this really brings together, from more a building view, of the individual residents and their individual needs into a single plan. So the purpose of this evacuation plan, as it's titled, is to essentially bring together copies of the information that relate to those residents who are not able to self-evacuate. So the points we've covered here, the flat and floor number of each resident that has a PCFRA, and an overview of the assistance required for each resident with a PCFRA. And finally, any information that's set out for that building by Regulation 9. That's the information sharing of fire safety information with residents. I foresee that Regulation 13 of these regulations does bring one or two challenges, because preparing an evacuation plan and bringing these together is going to mean that coordination of these different persons, and for a particularly large building this could be quite an ongoing task. Then there's part B of this, is to provide a copy of this information to the local fire and rescue authority, and then this is where it gets into another area. Where the building has a secure information box, place a copy of this building emergency evacuation plan in the box. And the plan must include instructions relating to residents' evacuation strategy for that building. So presumably simultaneous evacuation for some, but stay put for some high rise as well. And confirmation as to whether or not there are relevant residents. It may be at a certain point in time that the building evacuation plan simply states that there are currently no residents who have a PCFRA and are classed as a relevant resident. That would be great if we didn't have any of these in high-rise buildings, but I think we all know the truth is somewhat otherwise. There has been some statistics published about the percentage of persons in these buildings that would require a PCFRA. And I seem to recall that the percentage within social landlords properties is something like 28% of residents need a PCFRA and 14% in the private sector. I'm not sure how that information has been collated and the accuracy has been verified of that information. Again, this building emergency evacuation plan, once it's been formatted, must be reviewed no later than 12 months. And again, if there's any reason to believe that it's not up to date or sufficient. So if there's a reason under Part 4 of this Regulation 13, is if there's a reason to believe the plan requires amending, it will need to be reviewed. Again, providing a copy to the Fire and Rescue Service, updated, and providing an updated copy in the secure information box. So I'm just keeping an eye on the time so we keep sufficient space for questions at the end. Just about, if I just touch on a couple of points about the reviews that are required, I think this is where the ongoing nature of residential PEEPs comes in. I often liken this to the painting of the Fourth Rail Bridge. It seems like the job is never done, and I think that's something we need to understand about these new regulations. The point here is you've got a forever ongoing responsibility. There may be new persons moving into the block that fall into these needs of having a PCFRA. It may be that a person's circumstances change for good or for bad, and you've got to update it accordingly. It may be you've also provided mitigating measures, which means you can then update their PCFRA to include those mitigating measures that are provided. So in this context, I think you can see there's an ongoing nature of this is quite a significant step. This was actually shared by a senior person from the National Fire Chiefs Council, During the implementation review of these regulations, that it was felt this is potentially the most far-reaching set of regulations since the Grenfell Tower tragedy, in that a number of the requirements that have been imposed are things that have to be done once, such as providing a SIB or wayfinding signage or fire safety plans for a block, or even creating your first building safety case. The point particularly with this is the ongoing nature of its requirements, and also the way it requires you to interact and communicate with residents. So I trust that's clear for everybody. So when we talk about what's not clear, there's a responsibility in here for a resident's consent. So the Regulation 10 Part 2 sets out the responsible person must not provide the information to the local fire and rescue authority unless the relevant resident has given explicit consent to the provision of that information. Now, I see this could potentially be a barrier to persons assisting residents that do actually need a PCFRA, and they should be sharing that information, where persons, for some reason of their own, have given that refused to give that consent for the provision of information. So I'm sure this is going to be a grey area that's going to come up and is likely to raise some concerns. Mitigating measures, who pays for them? We already touched on this. Just to remind it's still unclear as to what might apply, because it isn't as specific as we'd like it to be in this regard. This is where I do believe some of this might be driven by a resident that's willing to pay for their own, for something that would assist them. But as soon as it becomes something that's for the benefit of the whole building, it seems crystal clear that it's going to become a service charge applicable item. The challenge then with this is you probably will think about budgets and what happens about next year when this comes into force, where there's costs, who pays for them, what do you put aside as a budget for that? That's a very difficult question that's still unclear as to what might be considered reasonable and proportionate, as we discussed. We've also got the examples there of, the points here about Regulation 10. So Regulation 10 is related to the provision of information to the local fire and rescue authority, where you have to provide the resident's flat number, floor number, and the information regarding the degree of assistance required. But it also goes on to Part 3 of that regulation, where it says that the responsible person must provide the information to the local fire and rescue service by whichever means the local fire and rescue authority chooses. So it may be that one fire service says, yes, we want you to share it with us digitally, and there's no need to put a copy in the box. It may be another fire service says, we want a copy in the box and we don't want you to share it with us digitally. And you may get another fire and rescue service that wants you to do both. It seems highly likely from the previous discussions and review into this that the fire service are very likely to want a copy in the box at all times. This is the bit we're probably, as block managers, we're probably hoping that the digital copy would suffice, because it's a lot easier to keep up to date with having to physically attend the block and actually open up the box and update the documentation. Certainly, I think most would prefer to do one rather than both options, but again, if the local fire and rescue service choose that you have to provide both options, then that's what you'd be required to do. Now, as yet, I'm not aware that any fire services have made it clear on this particular point what their position is, and I trust there will be a mechanism that can be rolled out that's clear for everyone for where their blocks are concerned. So the fire safety order is very, very broad as legislation, covers a lot of different property types in this country, which does include residential blocks of 2 or more flats. What it doesn't explicitly include under Article 6 is the flats themselves. I think you'd all agree that a number of the measures we've spoken about today, particularly relating to PCFRAs, relates to the flats themselves and the residents. So we do see this as a potential conundrum where what's been passed in these regulations actually goes beyond the scope of the fire safety order. Now, I cannot answer the question as to whether this has been thoroughly looked at. I know it was definitely discussed. I'm not sure whether there was a definition arrived at by MHCLG as to how they justify the these regulations being brought through where the fire safety order doesn't explicitly extend to this. It's potential that the Fire Safety Act might need to be widened its scope further, which if it does, that could be quite significant in order to widen that scope. But we're not clear as to the legal standing of these changes in the context of Article 6 of the Fire Safety Order. Now, that's probably something that none of you may feel particularly interested in, but it might affect how these regulations progress as we go forward, that's all. So I'm just conscious of the time and just want to say that we've got to the end of the training slides of what we want to cover today. And we'd like to open it up to questions that persons have. So please be free to put your questions into the Q&A. Vicky, I see there's some that have also gone into the chat, so we might just need to go back through that as well, do we?
We'll have to filter through. I'll do the first one that's in the Q&A first, and then we'll go through some of the ones in the chat. So the first question, they've not left their name, but it says, if a person-centered fire risk assessment is distinct from a standard fire risk assessment, how frequently should it be undertaken? And additionally, is this something a general fire risk assessor can carry out, or does it require a specialist?
All good questions, which I'd like Alex Norris on the session here today to answer. As he isn't, I'm going to share what I think is the answer to this question. So first of all, thank you for asking the question. A fire risk assessment is still not defined clearly enough for a lot of people as to how often they should be done. And often this is actually a requirement that's driven by stipulations by insurance companies more than by regulation. The point, of course, to understand about a fire risk assessment that also applies to a PCFRA is it's got to be up to date to today's risks. So it's not just a thing that's done once at a particular point in time and not touched again until that point in time comes up again. So first of all, it's firstly required if it's a person is identified that is a relevant resident. Once that PCFRA has been provided, then there's an ongoing responsibility review no more than 12 months later or earlier if there is reason to believe it needs to be updated. So that hopefully answers question one of two that's encapsulated in that question. The second question, which is about the general fire risk assessor or a specialist with specific qualifications. I'm sure you're all acutely aware of this, that the government have this ability to approach new regulations in the manner of making them sound simple and easy, such that anybody can actually do this themselves. The practice always proves something slightly different. From first-hand experience with a number of responsible persons, the first thing they want to do is pass this risk to someone that's more competent than themselves, because competency is something that we're not very good at defining in this country. And with competency in this context comes responsibility. With responsibility comes risk, and we live in a slightly risk-adverse environment, would you say, Vicky? And so people are, even though they could do this, they might not want to do this. So it's intended that it shouldn't need to be done by someone with lots of specialist knowledge, but the person that's arranging this might need to reach to someone with specialist knowledge to help them or reassure them they're doing the right thing, or in some cases, some people will want to choose to deliberately call in someone with specialist knowledge in order to help them in this way.
Yeah, sure. I can see there's a couple of questions there also asking about the recording and the slides. So yes, I will be sending that out once they've both been processed this afternoon. Okay, I'm just going to scroll through the chat because there was some going back to earlier on. So Harriet asked, is it down to the block manager to know if there are vulnerable tenants needing additional help within a building for escape? Or is it the responsibility of the vulnerable tenants to ask their block manager for the specific for their specific individual risks and evacuation information?
Well, it's a very good question. I think we did partly cover this in the session, but just to reiterate on this, is actually both. It's a bit like health and safety. It's the responsibility of the individual as well as the persons that are corporately responsible. So the block management, if they're managing a block with that's in this scope as a specified residential building, would need to evidence how you've collected information or gone about trying to identify relevant residents. And if by chance there weren't, that's one thing. then there's also responsibility on those residents that fall in this category of a relevant resident to come forward and identify themselves to the block management company with a view to meeting what's required here. So in a way, the relevant resident is a duty holder as well as the block manager. So hopefully that answers that question for Harriet.
So Camilla asked, this was earlier in the session, I think it was one of the forms that you were referring to. Can we all use the form used by the London Fire Brigade?
Of course you may. You may use whichever form you like. It just happens that for whatever reason they haven't included the London Fire Brigade PCFRA in the toolkit that was published, which surprised me a little bit, given that sort of 3/4 of the high-rise buildings across the country are based in the capital and fall within the scope of London Fire Brigade's region. So they're likely to have the most questions related to this just by the nature of the built environment that we have. So I don't see any problem with using the London Fire Brigade form. However, if your block is not in London, let's say it's in Birmingham, Manchester, Bristol, Newcastle, wherever you may happen to be, I would highly recommend that you look to your local fire and rescue service for what their version of this is.
Okay, thank you. I think you did already sort of touch on this earlier in the session, but someone was asking, what do we do if we know that there is a resident in a high-rise block on the 7th floor, but the person is not willing to share any details?
I think what you've got to look at there, so it's again a very good question. I see this is going to be potentially a challenge. I think communication with that resident is very important. If someone is deliberately not cooperating, they need to understand it's about their own safety. So the point, if you're aware, I think you've got to evidence your identification of relevant residents in Section 5. If that involves you've identified someone that should be going by these regulations, but they've explicitly refused to cooperate, you may want to consider that individual situation as to are there other risks that it poses to other persons in the block primarily, because if that person is posing risks to other neighbours in by virtue of their situation, that is something that would need to be seriously considered. And it may be a good time to bring in that support from the local fire and rescue service that may be able to give that person some advice that they might take from them that they might not want to take from you.
Okay, thank you. Someone was asking a question here, but I'm not sure what part of the presentation it was relating to. They was asking what if there is a disabled person in the building with a stay put evacuation policy. But I don't know what they was referring to when they
I
said
could probably still so in relation to this is probably in relation to an over 11-meter building that is stay put rather than simultaneous evacuation.
Yes, I think so, because the next question is in relation to the under 11 meters, so I think so.
Yeah, so if this is for a building under 11 meters or for an over 11-meter building that is a stay put policy, these regulations don't currently apply to those. So it does leave us a little bit in limbo in that area of our built environment as to what is considered as appropriate. What I do know is there are social landlords and councils that have implemented these same types of measures that we've spoken about today in their low-rise and mid-rise buildings that have stay put policies just the same, because I think we'd all agree that stay put is not the safest strategy in every situation, particularly if there's persons who can't evacuate, if that strategy needs to be changed in the event of a live incident at short notice. Suddenly that could pose a challenge that hasn't been considered for. So, good question, difficult one to answer.
Yeah, I'll try. I'm conscious we've got quite a few more there and some in the Q&A, but I'll try and get through a few more. So I think similar to that, someone said if the regulations do not apply to buildings under 11 meters and the site has a stay put policy, do we still need to try and identify relevant residents, even if it's only doing so as best practice?
Well, I think if you just think one step further than this, if you did identify them and you did do a PCFRA and you put some mitigating measures in place, that could never be a bad thing. We'd never recommend anyone to not do something. We're always trying to promote a positive culture of safety. So we would never stop people from doing that, but that's definitely going above and beyond what's required by the virtue of these regulations. But we are looking to raise our culture of fire safety in this country. So this is one example. The other side to it, of course, is if there isn't a facility then to share that information with the fire service, or you haven't provided a secure information box, that information that you've dutifully collected may never be used, which could make it ineffective. So it's
Yeah.
important to think about it holistically.
Okay.
So I think we're kind of almost at our end of questions there. I did see something in the chat I wanted to touch about letting agents, if I could just squeeze that one in there.
Yeah, that was the one after the next question. Are letting agents doing anything to help us?
It's a very good question. The fact of the matter is, the structure of the requirements and regulations is the responsible person to communicate directly with residents. I'm aware that there's a general approach to this at the moment where persons doing via leaseholders, via letting agents to the actual resident, which becomes a chain of communication which is easily broken. And sometimes it's broken by the leaseholder, sometimes it's broken by the resident not just cooperating with it, and sometimes it's where the letting agent, through whatever reason, there's a breakdown of communication. So, I am aware of this one here that persons are doing this. But they should have their mechanism for resident engagement directly with residents, not via other third parties. Trust that's clear.
Yeah, I think so. So we've just run over time actually. Sorry we can't get through all the rest of those questions. There's quite a lot, but I will be sending out a copy of the slides with the recording of the presentation. So if you would like to get in touch with Russell to follow up directly, then please feel free to do so. I'm sure he would be happy to hear from you. Thank you very much for joining. Thank you very much, Russell, for your time today, sharing all of your knowledge. If you would like to join us for more webinars, we have another one on this Thursday with Matt Lewis, who is going to be talking about the service charge consultation, which was also announced on the 4th of July. You can register for that on the News on the Block website. Otherwise, thank you very much for joining, and I will see you on the next one. Have a good day.
Thank
Thanks,
you.
Russell.
Thank you very much.
Bye.